Hello, welcome to our European Court of Human Rights and the COVID-19, which is organized by Science and the site of juridice.ro. I am Julia Motok. I am judge currently at the European Court of Human Rights, and I am professor at the University of Bucharest. I am delighted to welcome our very distinguished speakers of today. How to start a conference about COVID. Telling that when the hospital were filling up fast as COVID-19 began to spiral out of control, sales of Albert Camus' 1947 novel, La Peste, were rising. Its fictive chronicle of the measure taking in the city of Oran against the death-dealing disease that strikes in 1940 sometimes seemed to blur into the government announcement reshaping our life. Oran is a city like anywhere else, Camus said. And I will say now in French, as Camus wrote, nos concitoyens travaillent dur, mais uniquement dans le but de s'enrichir. Leur principal intérêt est le commerce et leur objectif principal dans la vie est, comme ils l'appellent, faire des affaires. Like people anywhere else, the Oranians are completely unprepared where rats began emerging for the sewers to die. The people of Oran initially disbelieved the plague outside of the page of history books. So, like many nations in 2020, they are slow to accept the enormity of what is occurring. As Camus continued, and now I'll say in English, in this respect, they were wrong, and their views obviously called for revision. So COVID-19 had barely affected those of the top end of the global economy and has devastating effect on the bottom parts of our economy and society, said Professor Stiglitz to the Human Rights Council. He also remembered that it's almost part of a right to life and yet access to the vaccine, while it's very easy in advanced country, is extraordinary social welfare and vulnerability, which including essays of a social determinants of health and corrosive nature of disadvantage, of vulnerability of children during school closure, and right to adequate housing. A very important theme of vulnerability regarding to the question of the COVID that was reminding from the beginning in the Human Rights Council was the question of economic justice and includes discussion of precarity, theme of in speech and misinformation, which examine issues such as efforts to repress misinformation about COVID-19 on social media, violates freedom of speech and moral permissibility of shaming those who flout social distancing guidelines. A disproportionate number of 3 million people worldwide who have died for COVID-19 are also victims of inequalities. So we have all these numbers, and we know that despite a surplus of vaccine in the rich world, the global south has fewer than the tiny amount that led to expect. So this is the global picture of the COVID-19, the global picture of the COVID-19, especially in the relationship between the North and the global South, and to see which are the consequences today for our society and for developing the problem of the related to COVID-19. Dealing with the pandemic through the prism of law is not an easy task, especially when you consider where we stand. We are not at the time of taking stock, nor we are at a stage of mere reproduction and even fiction. We are, unfortunately, still in what Shakespeare described in The Tempest, what's past is prologue. The fundamental rights and human rights obligation of Romania as a EU member state also derive for other international human rights instruments. These include the European Convention on Human Rights, the European Social Charter Treaty System, as well as instruments adopted within the framework of the United Nations, such as International Convention on Civil and Political Rights and Economic, Social and Cultural Rights. In addition, fundamental and human rights are well entrenched in the constitution and legislation of the EU member state. They are also part of their common values of which EU is founded. International Court has referred to the negative duty of the state not to infringe the ability to access health care. The International Court of Justice, ICJ, determined in an Israeli war advisory opinion legal consequences of the construction of the wall in the occupied Palestinian territory, that Israel's erection of a separate barrier between West Bank and Israel restricts access to health services and thus violate the International Covenant on Economic, Social and Cultural Rights in this Article 12, the right to health. Our court, the European Court of Human Rights, has at least once interpreted the European Convention on Human Rights as imposing health-related duties on state part, once before the pandemic. The court grand chamber held in Cenk versus Turkey that Turkey had not taken sufficient care to ensure the health system functioned appropriately. Researchers have suggested that despite the absence of an explicit right to health in the European Convention on Human Rights, prior court judgment can be read as extracting a positive duty to health protection for state parties based on Article 5, Paragraph 1, right to liberty and security. This is also to discuss. Further, the right to health is not solely positive, but there is a strong presumption that retrogressive measures taken in relation to the right to health are not permissible, and state parties should refrain from interfering directly or indirectly with the enjoyment of the right to health. Regarding our court, we have to say that we already received around 307 requests for interim measure related to COVID-19 health crisis. The majority of these requests were based on Article 2, right to life, or Article 3, prohibition of torture, and were made either by migrants or detainees. The first measure, the first article, section 39, benefits were granted in cases against Greece, 50 cases against Greece. Asylum seeker or people held in traffic or assessment center were asking to be released due to the overcrowding, lack of infrastructure, and risk of contamination of COVID. The court took into account the particular vulnerable situation of certain applicants, of minors with mental problem, of elderly, pregnant women, and women with newborns, and ordered Greece to offer the reception condition and the care compatible with their state of health. Other measures follow this kind of measure, but majority of them, they deal with this category of vulnerable people like migrants or detainees. A lot of other complaints were communicated, but by now the court had decided in few of them. The court, for instance, held that there had been a violation of Article 3, prohibition on human or degrading treatment of the Convention on account of the applicant inadequate condition of detention in a Maltese case. The court was concerned about the applicant's assertion, not rebutted by the Maltese government, that following an isolation period, the applicant has been moved to other living quarters for, where new arrival had been kept in COVID-19 quarantine. There was no indication that the period, which moreover had lasted nearly 7 weeks, thus the measure of placing him for several weeks with other person who could have posed a risk to his health in the absence of any relevant consideration to that effect could not be considered a measure complying with basic sanitary requirements. So we found a violation of Article 3. Other complaints now that are communicated under Article 3 follow a request for extradition to the United States of a 60-year-old man suffering from pathologies, asthma and diabetes, and likely to suffer as a result of a pandemic in human condition and degrading. Violation of Article 11, freedom of assembly and association, following a general ban of all public demonstration which forced the applicant, a worker defense association, to cancel a demonstration if they wanted to organize. Also violation of Article 5, right to liberty and security, invoked by the applicant in prison in Cyprus, whose extradition to Russia was suspended due to health crisis. Violation of Article 8, right to respect for private and family life, invoked by a father who, in the context of his legal separation procedure, wanted justice to rule urgently on the custody of his 5-year-old daughter, taken by his wife away from him. Violation of Article 10, freedom of expression, following an Instagram post that was sanctioned by the court for exposing figures of virus contamination and virus-related death deceptively inflated by authorities. So right to protect health, as we said, by the 47 signatory states of the European Convention, must adopt a regulation applying in places where health must be guaranteed. And we have several judgments of our court when we speak about goals to be protected. And our colleague, the judge Wikström Moru, has identified the ultimate goal to protect the life of patients. Article 2, we refer to, for instance, to the judgment Lopez de Sousa and Fernanda de Oliveira against Portugal. The end of life situation and interruption of the life support system that have given rise to particularly difficult situation, like in cases like Lambert versus France and Guard versus UK. Under the prohibition of inhuman and degrading treatment, the court has to deal with the explosion of seriously ill persons, like in Popashvili versus Belgium or Savran versus Denmark. There are some of very interesting cases that point out Article 8, especially that the last case that we had during the pandemic released in April 2018, Vavrika versus Czech Republic. So we have to recall this case. This case is very important. It was not always interpreted in the right way. So in the Czech Republic, there is a general legal duty to vaccinate children against 9 diseases that are well known to medical science. Compliance with the duty cannot be physically enforced. Parents who fail to complain without good reason can be fined. Non-vaccinated children are not accepted in the nursery school. An exception is made for those who cannot be vaccinated for health reasons. In the case of Vavrika, the first applicant was fined for failure to complain with the vaccinated duty in relation to his children, and the other applicants were all denied admission to nursery school for the same reason. In this case, the court pointed out that under the case law, compulsory vaccination as involuntary medical intervention represent an interference with physical integrity and thus concern the right to respect for private life protected by Article 8 of the Convention. It recognized that the Czech policy pursued the legitimate aim of protecting health as well as the rights of others, noting the vaccination protects both those who receive and those who cannot be vaccinated for medical reasons, and therefore reliant on herd immunity for protection against serious contagions. And the court considered that a wide margin of appreciation was appropriate for the respondent state in this context. It could be said that represented that the national authorities answer to the pressing social need to protect individual and public health against the diseases in question and to guard down against trend in the rate of vaccination among children. So the court observed that the vaccination duty concerned 9 diseases against which vaccination was considered effective and safe by the scientific community. And the court examined the proportionality afterwards of the vaccine policy. On a general level, it noted that the scope and the content of the duty to vaccine, the existing exception for it procedural safeguards available. So in this case, as you all know, the court has said that we don't have a violation of Article 8.8. What is very important to notice is that the court in this case had dealt extensively with the question of the rights of children and the best interest of children in the convention, and with the question of the proportionality of the vaccine, of this particularly 9 vaccine. So it is nothing that can be interfere for this other kind of vaccination from this judgment, as it was sometimes reported by some experts or by the press by that time. So we should also bear in mind that we have several other circumstances, other jurisdictions that were and are confronted with the question of the compulsory vaccination. And we have in Europe, we have less case law regarding this question, but we will always have debate that invoke the possibility to raise the freedom of conscience that is recognized by the Article 9 of the European Convention on Human Rights, and the problem of the right of conscience objection that is so well represented in our case law, especially following the case of Batayan versus Armenia. But we have this case law, as you know, probably in the United States, when recently on the 29th of October, the Supreme Court declined an application for emergency relief to block the state of Maine mandate for healthcare workers to be vaccinated against the coronavirus, a requirement that allow non-religious exemptions. So we see that in this case, the Supreme Court agree with the main policies that mandate healthcare workers to be vaccinated against the coronavirus. Of course, we have the three judges that are dissenter, especially talking about religious belief, but the decision of the court is such as I said. So we have a federal appellate court that in the October 29 remove a temporary order that has let healthcare workers in New York seek religious exemption to the state COVID-19 vaccination mandate. And New York law now permit exemption only for medical but not religious reasons. So before even on the 1st of October, the Supreme Court Justice Sonia Sotomayor declined to block New York City COVID-19 vaccination mandate for all City of Department of Education employees. So we see that the Supreme Court is keeping the same case law in this direction, interpreting the legislation in this direction. This is the reason why also American authorities and President Biden believe that putting a mandate of which would make businesses with 100 or more employees requiring their staff to get vaccinated, it will be a positive measure to hasten the end of the coronavirus pandemic. The situation is different in Europe. To come back, so we know that in order to assess this limitation to freedom, the court must weigh, accordingly to the formula established by our case law, competing rights, competing health, collective health versus individual freedoms. These balancing acts find its architectural expression in two areas of justice that make up the building of the European Court of Human Rights. Is the foundation of all the right for justice of our convention. We have another question here facing in the convention that maybe is a little bit more complicated, and five of our speakers will talk about this. Is regarding the request of the judge of the declaration of derogation in conformity with Article 15 of the Convention. Article 15 of our Convention is a tool available to states which allows certain rights of the Convention to be derogated from in the event of exceptional and imminent crisis or danger. From the first judgment in the history in 1961, Lawless versus Ireland, the court was required to frame the exception decided in the name of urgency. It is in the difficult political context, which was the conflict in North Ireland. The development of the disease, starting with the pandemic, 10 member states of the Council of Europe, Albania, Armenia, Estonia, Georgia, Latvia, North Macedonia, Moldova, Romania, Republic of San Marino, and Serbia, has declared to the Secretary General of the Council of Europe that they could take measures derogating for the obligation of the Convention. The concept of a state of exception has a very long history. Since discussion upon can be traced back to the French Revolution, it defines as a special condition in which the juridical order is actually suspending due to an emergency or a serious crisis prevailing on the basic laws and norms can be violated by the state while facing the crisis. The idea that the exception is a fundament of law has been formulated more recently by George Agamben, but has been developed by the famous philosopher and, of course, crown jurist of the Reich, Carl Schmitt, and by Walter Benjamin in the first decades of the 20th century. Agamben started now his inquiry about theoretical perspective aiming at the formulation of a general theory of a state of exception, which he claims had become the dominant paradigm of the government in contemporary politics. He reads the emergence of the exception in Foucauldian senses. He focuses on the famous notion of biopolitical significance of exceptionalism as a widespread political device. For Agamben, such suspension of a law is pivotal to its directly affect the people's life, not only the subject of politics as citizen, but as human being as such. The locus where people are strived to bear life as defined by him are concentration camp in Nazi Germany. So we see completely different situation. The same theory of the state of exception is less known, but was developed also by the concept of necropolitics, in the use of social and political power to dictate to some people may live or must die, of the philosopher Achille Mbembe, in the author of the book on the post-colonialism and of the book in 2019 about necropolitics. He also in his book discussed the extension of biopower, the Foucauldian term, and also the question of controlling people life, but especially the problem of the fact that under the condition of the necropower, the lines between resistance and suicide, sacrifice and redemption are blurred. He discussed the obligation of the countries they have in theory not to expose their citizens to death, which happen in with a lot of countries. Following advices from international and European health institutions, more member states have used digital tracing and tracking tools to limit the spread of the pandemic, especially contact tracing application. Some countries have also allowed health and policy authorities to access traffic data and geolocalization data provided by telecommunication operators to track certain individuals subject to quarantine measures. Regarding contact tracing application in the context of the COVID-19, the European Convention and the European Data Protection have adopted guidance on how to comply with the data protection standards because, of course, this implies the GDPR and also the question of the EU Charter. Another question is the days of extraterritorial application of the context of the COVID-19. I think that my colleague Jasabata will speak about this. So talking about the underlying intent of the convention and general content, we see the possibility to see also an extraterritorial application in the context of COVID-19. To finish, to conclude, I would say that for the first time in the very long time, philosophical consideration has become the stuff of political debate and everyday conversation. The word seems stemmed by ethical consideration: is there a right things? And the word says teaming to do. And they are now everyday question for most people, and many politicians in particular is standing accused of having done the wrong thing, the wrong decision. So ethical things, philosophy can help to inform and what we want to do given what we know. So ethical and philosophy things, also philosophy of law became everyday question for every of us. So, thank you very much. Maintenant, je vais donner la parole à mon collègue Mathias Guimard. Mathias Guimard, il est juge à notre cour. Il représente depuis peu de temps, il représente ici la France. Avant, il a eu une carrière brillante au Conseil d'État, mais aussi en tant qu'universitaire. Il était à l'ENA aussi, il a fait des cours à l'ENA aussi, mais auparavant, il a enseigné à plusieurs universités, y compris à SAS. Donc, le juge Guimard, il va parler maintenant sur notre jurisprudence concernant la France et les cas de Covid-19, jurisprudence qui est assez riche et dont je n'ai pas parlé du tout pour laisser la parole au juge Guimard. Je vous en prie, juge Guimard.
Merci beaucoup, chère Yulia. aussi pour ces mots très gentils de présentation. Bonjour à tout le monde. Merci pour l'invitation à participer à ce webinaire. Je suis très content de pouvoir échanger avec vous, même si ça n'est pas en présentiel. En effet, je vais essayer de compléter un petit peu en faisant le focus sur la situation française et je reviendrai très partiellement sur certains éléments que la juge Modoc a bien voulu mettre en introduction pour voir un peu comment se situe la France et les cas français par rapport aux cas Covid. Comme il a été dit et comme vous le savez, en fait, il y a forcément, en raison de la règle de l'épuisement des voies de recours internes, un effet retard entre la crise sanitaire et les affaires devant notre cour. Cela est normal, car ce sont d'abord aux juridictions internes qu'il revient de trancher les nombreux litiges que les mesures prises pour lutter contre la pandémie, ou l'absence de mesures parfois, ont suscité. Il y a une exception à cela, ce sont les mesures provisoires de l'article 39. Ça, c'est vrai que nous avons cette possibilité, en vertu de l'article 39 du règlement de la Cour, de prendre des mesures pour éviter la réalisation d'un dommage irréversible. Et il y a, ça a été dit, un certain nombre de mesures qui ont été demandées à la Cour depuis le début et qui sont liées directement à la crise sanitaire. Aujourd'hui, nous avons presque 370 affaires, demandes qui sont venues devant la Cour. Il y a des demandes de type différent, ça a été dit, beaucoup touchent les conditions de détention, par exemple. Certaines concernent des questions d'obligation vaccinale ou de passe sanitaire. La caractéristique de la France, et c'est vérifié aussi sur les requêtes au fond, c'est que mon pays fournit beaucoup de demandes. Voilà. Et je constate qu'il y a effectivement d'autres États, l'Italie d'ailleurs, et mon ami Raphaël pourra parler tout à l'heure, fournit pas mal de demandes et de requêtes aussi. La Grèce, ça a été dit. Mais en France, il y a une contestation assez importante par la saisine des tribunaux, c'est vrai dans l'ordre interne, c'est vrai pour notre cour, plus élevée que la moyenne. Et c'est assez intéressant de voir qu'en France, nous avons aussi un taux de vaccination plus élevé que la moyenne en Europe, mais nous avons une contestation politique et sociale plus forte, qui se traduit aussi par une stratégie contentieuse plus importante. Je pense que c'est assez intéressant comme contexte de voir qu'il y a une minorité, mais elle est très active, y compris juridictionnellement. Et nous avons eu des affaires qui concernaient, par exemple, les sapeurs-pompiers, en article 39, plusieurs, de très nombreuses affaires. Aujourd'hui, nous en avons plusieurs centaines qui sont à l'instruction, qui concernaient l'obligation de vaccination. Nous les avons traités en 39 et nous les avons rejetés comme out of scope, hors champ de la mesure 39. Et je voudrais dire un mot pour expliquer le raisonnement tenu par la Cour. Nous l'avons rejeté en collégial, parce que d'habitude, vous le savez sûrement, ce sont des juges uniques, des juges de permanence, qui décident de donner satisfaction, de rejeter les mesures 39. Mais quand la question est importante, sensible, pose des enjeux systémiques, nous pouvons renvoyer en collégial. Et cet été, au mois d'août, nous avons fait ce choix, et je crois que c'était très sage, de traiter en formation collégiale ces mesures qui demandaient à la Cour d'ordonner la suspension de l'obligation de vaccination pour certaines professions. C'était les pompiers qui étaient essentiellement à l'œuvre. Nous avons dit out of scope en 39 avec un raisonnement qui est le suivant. L'article 8, qui était invoqué, n'est normalement pas dans le champ d'application de l'article 39 parce que, vous savez, pour que la Cour intervienne, il faut qu'il y ait un risque de dommage irréversible. Et ça n'est que de manière très exceptionnelle qu'une atteinte à 8 peut être regardée comme de nature à provoquer un dommage irréversible. Donc, c'était assez classique. Pour l'article 2, qui était invoqué aussi, le risque de porter atteinte au droit au respect à la vie, il y a eu un raisonnement intéressant qui consistait à dire « vous n'êtes pas obligé d'être vacciné de manière absolue ». C'est heureusement d'ailleurs pas le cas, on ne vous vaccine pas de force. On soumet l'exercice de votre fonction à une obligation vaccinale. Et si vous ne voulez pas, vous êtes suspendu. Et vous n'avez pas d'argent. D'ailleurs, c'est une des questions, article 8, que nous allons retrouver au fond dernière. Et donc, il n'y a pas de risque vital parce qu'on ne vous force pas à supposer que le vaccin puisse entraîner un risque pour la vie. De toute façon, vous n'êtes pas forcé à être vacciné. Et je trouve que juridiquement, c'est intéressant comme raisonnement. Alors maintenant, ces affaires sont à l'instruction, nous les avons communiquées au gouvernement, et il y a le contradictoire. Et il en arrive tous les jours. Il faut que vous sachiez, ça traduit aussi ce que je disais, l'activisme judiciaire qui caractérise la France. Tous les jours, nous avons des nouvelles affaires sur l'obligation vaccinale et qui concernent d'autres métiers que les sapeurs-pompiers. Au départ, nous avions 670 affaires. Là, la semaine dernière, j'ai fait le point, 150 en plus. Donc, ce sont quand même des volumes très importants. Et nous allons devoir, en début d'année prochaine, rendre une décision, enfin des arrêts, sur le fond et juger, par exemple, si cette obligation est proportionnée par rapport à l'atteinte à la vie privée, qui consiste à dire vous avez le choix entre travailler si vous êtes vacciné alors même que vous ne voulez pas, ou ne pas travailler et ne pas avoir d'argent. Ce sont des questions délicates et qui peuvent intéresser effectivement de nombreux États au sein du Conseil de l'Europe. J'ajoute qu'avec les annonces faites par certains pays de la vaccination obligatoire à l'échelle de la population, ce sera aussi très intéressant. On a parlé de Wawrzyka contre République tchèque sur les vaccinations obligatoires. Là, ça ne traitait pas du Covid, évidemment, mais là, nous allons aussi avoir des décisions à rendre qui seront porteuses de lignes d'équilibre. On ne va pas tout trancher, évidemment, sur cette affaire, mais ça sera important. Voilà la première chose que je voulais dire. La deuxième chose que je voulais dire, et ça renvoie à l'épuisement des voies de recours internes, c'est que nous avons eu cet été presque plus de 20 000 affaires qui sont arrivées aussi contre le pass sanitaire. Cette fois-ci, ce n'était pas l'obligation vaccinale. Et nous avons rendu une décision, nous avons choisi une décision. Pourquoi nous l'avons choisi? Parce que c'était le monsieur qui avait organisé cette flux de requêtes, monsieur Zambrano, qui est un maître de conférence à l'université. Il a tout simplement créé un blog avec un formulaire type. Et il a invité, nous avons d'ailleurs regardé ses blogs et ses messages, il a invité les gens à venir saisir la Cour de manière massive, et vous avez vu ça a marché, pour contester le pass sanitaire. Et nous sommes arrivés avec plus de 20 000 requêtes, et elles étaient identiques. Elles n'étaient pas circonstanciées. C'était vraiment le nom qui changeait, mais il y avait quand même un nombre considérable d'affaires. Alors, nous avons décidé de traiter une affaire qui a été rendue au mois d'octobre, le 7 octobre 2021, et elle a été rejetée, cette requête, comme irrecevable. Nous avons mobilisé deux terrains, et réservé une question. Le statut de victime, la qualité de victime a été réservée, et je crois que c'est assez sage. Je reviendrai tout à l'heure sur une autre affaire française où nous avons dénié la qualité de victime. Là, on a dit, nous n'allons pas nous prononcer sur la qualité de victime, parce qu'il n'y a pas besoin. Il y a deux fondements, un qui ont semblé incontestables, qui entraînent l'irrecevabilité de la demande. Le premier, c'est le non-épuisement des voies de recours internes. Car il y avait eu une volonté délibérée de venir directement devant notre cour, sans passer par les juges internes. Et c'était expliqué dans le blog, parce qu'en France, il y avait eu le Conseil constitutionnel qui avait été saisi de la loi, dans le contrôle de constitutionnalité, la loi qui était le fondement législatif des mesures prises par le décret et les mesures individuelles après. Et le Conseil constitutionnel français avait dit la loi est conforme à la Constitution. Et ce que disait le monsieur et les autres requérants, c'est que ça ne sert à rien d'aller devant le juge ordinaire français, même en invoquant la Convention européenne, parce que comme le Conseil constitutionnel a déjà dit que c'était conforme à la Constitution, c'est déjà perdu d'avance. Donc le recours est inefficace, aller directement devant la Cour européenne. Mais ça ne marche pas comme ça. Et nous avons rejeté pour non-épuisement des voies de recours internes, car en expliquant d'ailleurs dans la décision très clairement le mode d'emploi, comment il lui fallait faire. Il y a un juge en France qui était compétent pour cela, c'est le juge administratif qui en référé, peut même se saisir de la conventionnalité de la loi. Et ce n'est pas la même question, même si les droits sont assez analogues. Ici, nous le savons très bien, nous pouvons juger contraire à la Convention des dispositions qui auraient été jugées conformes à la Constitution dans les ordres internes. Et il fallait passer par cette case-là de l'épuisement des voies de recours interne. Je crois que c'est la bonne façon de procéder, c'est la responsabilité partagée, c'est la subsidiarité, ce sont les principes directeurs du fonctionnement de notre système. Et c'était le premier terrain. Ce qui est intéressant, et je voulais ajouter quelque chose, c'est que nous avons aussi mobilisé le caractère abusif de la requête. Deuxième terrain d'irrecevabilité. Parce que nous avons vu qu'en fait, il y avait une stratégie. Et d'ailleurs, dans les discours que le monsieur tenait, et nous les avons cités dans la décision, il disait il faut submerger la Cour sous les flux de requêtes parce que elle est, d'une certaine manière, elle fait partie du système. Et donc, il faut s'attaquer au système en s'attaquant à la Cour, voyez-vous. Et il y avait très clairement une stratégie de déstabilisation de notre institution. Mais nous n'avons pas du tout pris ça à la légère et nous avons bien vu que cette stratégie de déstabilisation, qui était contraire à la philosophie du droit de recours individuel, c'est le copier-coller 25 000 fois de la même requête, nous l'avons considérée comme abusive. Voilà. Et donc, en rejetant cette décision, nous avons dit que ces motifs pouvaient s'appliquer aux 20 000 autres affaires qui étaient introduites devant nous. Alors, je crois que c'était intéressant de partager ce que nous avons fait ici, s'agissant de cette spécificité française. Et vous voyez, quand je disais qu'en France, il y a particulièrement beaucoup d'affaires portées devant les tribunaux, c'est pas peu de le dire. Nous avions ici plus de 20 000 affaires. Alors, je pense que c'est assez intéressant. Là, sur ce terrain de l'irrecevabilité, ça laisse entière les questions qualité de victime et bien fondée, évidemment, des griefs. Sur la recevabilité, encore un mot sur une autre décision qui est antérieure, elle date de novembre 2020. C'est une décision de comité d'irrecevabilité, le Mayou contre France. C'était un monsieur qui était, lui, venu devant le juge administratif français et qui avait donc épuisé les voies de recours internes. Et c'était en réalité une demande dans l'autre sens. Il ne disait pas qu'il y avait trop de contraintes, il disait qu'il n'y avait pas assez de protection. Et dans cette affaire, c'est intéressant de voir que le juge peut être saisi aussi pour des allégations de carence dans la protection. Et il était demandé à l'État de fournir des masques et des moyens de tests massifs pour la population. Mais nous étions il y a un an, et c'est vrai qu'il n'y avait pas la même situation de ce point de vue-là qu'aujourd'hui. Et il n'était pas parti devant le juge administratif français, il était intervenant à l'appui de requêtes qui avaient été portées notamment par un syndicat de médecins. Et devant nous, il ne venait pas dire dans quelle mesure il était victime des violations aux droits qu'il invoquait. Il invoquait 2, 3, 8 et 10. Mais ça n'était pas circonstancié. Et pour ces deux raisons-là, le fait qu'il n'était qu'intervenant dans l'ordre interne et que devant nous, il n'avait pas donné des éléments justifiant d'une atteinte personnalisée dans ses droits, nous avons jugé qu'il n'avait pas la qualité de victime. Je crois que c'est assez intéressant parce que ça veut dire aussi que dans le contrôle in concreto que nous exerçons ici à la Cour, nous demandons évidemment plus qu'une contestation de principe des mesures ou du refus d'en prendre, nous demandons vraiment de démontrer, d'établir dans quelle mesure personnellement le requérant est victime de la violation qu'il allègue. Et ça, je crois que c'est très important parce que c'est notre rôle. Nous ne sommes pas là pour juger des politiques générales. Nous ne sommes pas là pour dire si en général un vaccin ou en général un pass sanitaire, c'est trop, ou en général pas de masque gratuit, c'est pas assez. Nous sommes là pour dire, dans un cas particulier, est-ce qu'il y a une atteinte? Et s'il y a une atteinte, est-ce qu'elle est justifiée? Et ça, nous le rappelons aux requérants, c'est toujours une concreto. C'est comme ça que ça marche, le recours individuel. Je voulais partager avec vous ces questions françaises, franco-françaises. Je les trouve intéressantes de ce qu'elles disent de la situation en France, de ce qu'elles disent de notre contrôle aussi, de ce que nous pouvons faire et de ce que nous ne pouvons pas faire, et de ce qu'on parfois on nous demande de faire en sachant qu'on ne peut pas le faire pour nous déstabiliser. Ça, je crois que c'est très intéressant aussi. Alors, il y a des affaires pendantes. C'est vrai que sur la France, nous avons aussi des affaires qui concernent des textes qui ont été pris pendant la première période de confinement qui permettaient de prolonger automatiquement les détentions provisoires sans l'intervention d'un juge. Ce sont des textes qui ont été appliqués et qui ont été appliqués à des requérants. Donc nous avons communiqué ces affaires, elles sont à l'instruction et nous les jugerons l'année prochaine. Est-ce que l'article 5 s'y retrouve ou non? Ce qui est intéressant, c'est qu'il y a eu, de ce point de vue-là, une intervention du Conseil constitutionnel français déjà, qui a jugé que dans une certaine mesure, ça n'était pas conforme à la Constitution. Donc, nous verrons ici ce que nous en dirons au regard de la Convention. Nous avons eu aussi des demandes, mais qui ont été fréquemment rejetées, ces fois-ci en 39, dans les prisons ou les centres de rétention de demandeurs d'asile. Souvent, en réalité, il y avait un problème soit d'insuffisante éléments pour circonstancier les requêtes, soit parce que parfois le gouvernement avait fourni des informations qui semblaient satisfaisantes au regard des exigences qui pèsent en matière d'obligations positives, notamment au regard de deux. Mais je voulais dire que nous avions aussi un certain nombre d'affaires sur les personnes qui sont en situation de particulière vulnérabilité par rapport à la santé ou à l'exposition à des risques sanitaires, parce qu'ils ne sont pas libres d'aller et venir, ni libres de tous leurs mouvements. Mais ça, vous le savez, il y a eu beaucoup d'affaires qui concernent notamment l'Italie et la Grèce aussi de ce point de vue-là. Voilà, je ne veux pas parler trop longtemps parce que je sais que d'autres orateurs vont intervenir. Mais je suis à votre disposition si vous souhaitez poser des questions. Ce qui me frappe, et ça sera ma conclusion, c'est qu'indépendamment du cas français, et compte tenu de l'effet un peu de délai que l'instruction des affaires après épuisement des voies de recours internes implique, je trouve quand même que, comme toutes les crises, et Raphaël va en parler très certainement, on se trouve face à des mesures qui touchent à tous les droits. Et c'est ça qui me semble assez intéressant. Le cas français, de ce point de vue-là, il est comparable aux affaires concernant d'autres pays. On a une palette très grande de droits qui sont impactés. Là, je parlais de droit de procédure avec la prolongation, évidemment, automatique. Ça peut être du 6, volet pénal, ça peut être du 5, bien sûr. On parlait de l'article 2, ça va de soi. L'article 3, il y a le droit à la santé. La liberté d'aller et venir avec l'article 5. Bon, même s'il a été jugé dans le cas roumain que le confinement n'était pas une mesure privative de liberté. Mais on a aussi, et ça c'est assez intéressant, des affaires pendantes sur l'article 9 et le fait de ne pas pouvoir exercer son culte. Et donc, je trouve que ce qui est le signe que c'est une crise majeure, d'une certaine manière, qui impacte toute notre vie, toute notre façon d'exercer nos droits en temps normal, ce qui renvoie à l'état d'urgence, c'est que ça touche toute une série de droits différents pour la même raison, qui est la protection de la santé publique. Donc, c'est une crise totale, si je puis dire. Voilà. Et nous sommes appelés à nous prononcer dans des configurations très différentes et qui touchent à tous les segments de notre vie. Voilà. Voilà ce que je voulais partager avec vous. Je remercie encore Yulia de m'avoir permis de faire cette intervention. J'espère que ça vous aura intéressé et je me réjouis de poursuivre nos échanges. Merci à vous.
Je remercie beaucoup le juge Guimard pour cette brillante intervention et pour avoir accepté notre invitation. Et oui, sans doute que le contentieux français est en ce moment un des plus riches contentieux concernant le Covid qui se trouve devant la Cour. Il faut aussi dire que la Cour, peut-être il n'y a pas beaucoup de nos collègues dans l'auditoire qui le sachent, la Cour, elle a changé la politique déjà de communication des cas. Donc, elle communique d'abord les cas qui ont un certain conséquence, qui ont un certain impact, comme on dit en anglais, sur le pays ou sur en général la situation des droits de l'homme en Europe. Et ça fait que certainement, la Cour faisait ça même avant. Donc, on avait des affaires qui ont été jugées très rapidement, des affaires qui étaient importantes sur les conséquences des droits de l'homme, mais ça est devenu une politique. Et on a vu la vitesse avec laquelle on a communiqué et on a même décidé dans certains cas, le juge Guimard a fait référence à cette affaire roumaine, je l'ai plus citée concernant Monsieur Terhesh et l'article 5 et le fait que le confinement n'appartient pas à cet article. Donc, en général, on a adopté des décisions de irrecevabilité, mais ils sont déjà adoptés. Et je pense que c'est important pour c'est important pour les gens qui nous écoutent de la Roumanie aussi de l'Europe de savoir que ce cas Zambrano et le concept même de l'abus de requête qu'il implique, qui n'est pas si connu par le public. Donc, on voit que la Cour applique cette notion de l'abus de requête chaque fois où on se trouve dans une multiplication des, on se trouve dans une tentative, dans une idée de bloquer la Cour, tel qu'elle était le cas dans cette affaire. Et peut-être de cette manière, la Cour, elle se défend contre la possibilité que ça se passe avec des autres requérants dans des futurs qui montent de telle affaire ou tel mouvement. Voilà, donc c'est vrai aussi ce qu'on avait dit avant, c'est une crise majeure qui touche tous les articles de la Convention et donc nous, on est censé de trouver en équilibre. Maintenant, pour faire la tradition, je vais le faire toujours en français parce que le professeur Cosmin Churchill, il est aussi éduqué en Roumanie et en France. Donc, il était éduqué à l'université de Bucarest et à l'université Pantin-Sorbonne où il a fait aussi son doctorat et après, il a fait aussi des études postdoctorales. Et maintenant, après un parcours académique qu'il a mené dans plusieurs autres universités, il est professeur à l'université de Nottingham. Donc, Professor Churchill will talk about pandemic exception and the law between text and context. I have to say that he's teaching the theory of law, introduction in law, and also comparative constitutional law. You have the floor, Professor Churchill.
Okay, so thank you very much. I'm very happy to be invited. Thank you, Julia, for inviting me. It's not every day that I get to be in the same virtual room, at least with judges from the European Court of Human Rights. So I think this is quite important for me. And I think it's quite important as a more general trend. I think Julia mentioned it before, the fact that we need to have some sort of a way of connecting perhaps the field of inquiry and what I'm going to say in a bit, the field of critical inquiry, philosophy, theory, legal theory, to the field of practice. And I think that the question, it is also, because I don't think that we speak enough to each other up to a point. And I think that there is also another point that I would want to raise from the very beginning in order to kind of give you a sense of where I'm trying to go to. It's also the fact that we're sort of seeing this sort of lacks of relationship, perhaps, or reflection on history and perhaps philosophical matters. And unfortunately, the past is sort of catching up with us. My point is, I'm not here to speak as a lawyer of European human rights law. I'm much more here present as to speak a bit as a legal historian. Now, I'm a specific type of legal historian. I come from a tradition that is called critical legal studies, which unfortunately didn't find quite a lot of roots within on the continent. But basically, what I'm going to try to explore a bit, it is the question of context. And to give you a bit of a sense of where I feel that we unfortunately are. And from this point of view, I think that it is really not a very difficult task that any sort of judges under these particular conditions are going to face, actually. But so much more judges of one of the most important jurisdictions in Europe. And perhaps in the world as well. And I think this is sort of a difficult task to deal with because it's for the first time, I think that we have actually the whole world, but what concerns me more is Europe under emergency legislation, being issued since March, perhaps February 2020. And it is for the first time that we have this since the end of World War II. And I think this is something which is quite important. Now, what I'm going to try to say, to bring a bit on the table it is the sort of historical weight that it is behind us. Now, we have a long theory, we have a long experience of emergency legislation in Europe, which could go back to, if we wanted to go back, we can go back to the French Revolution. We can go even back furthermore to the dictatorship, to the institution of dictatorship in Rome. But the way in which we have been theorizing it during the past years, and it started with around 2003, 2004, once we had to respond to the terrorist threats after 2001. We have been keeping to a specific way of theorizing emergency and emergency legislation as something which is essentially conservative. Essentially conservative in a sense that these are measures which are going to be there only for a temporary period of time, and then when we're going to get back to normal. And I'm referring here to one article by John Farragon and Pasquale Paschino, which was very influential article called "The Laws of Exception: A Typology of Emergency Legislation." Now, my point and my general point, and when I'm going to try to explain why I'm making this claim, my point is that this is not entirely true. I think it becomes, and it becomes perhaps visible to us, and it's probably one of the good things, well, if there is anything positive about it, about the virus, deadly virus looming around. It is the fact that we're going to be able to see that perhaps emergency has a very important place within the history of our legal communities. And when I speak, when I'm saying this, I'm just, I just wanted to bring you a couple of examples from the past. And if we're looking at the European legal history after the French Revolution, going to see that basically this institution of emergency legislation, the first one which emerged in France, it was called l'état de siège, so the state of siege, circulated all across Europe. And it was used in important moments, 1848, once again, all across Europe. The Romanian, for instance, just to give you an example, the Romanian first instantiation of what we call the state of siege originates from a translation of the French state of siege of legislation of 1849, and it emerged in Romania as a part of the Code for Military Justice written in 1852. So I think we can see that this traveled relatively fast for those particular periods of time, and I think it is a specific technology of dealing with threats, threats to the Constitution, but more than that to the state itself. Now, if we're going a bit further in time, we're going to see that there is a constant, and this can be demonstrated, in development of emergency from 1914 onwards. And from 1914 onwards, most of the countries on the continent, and even on the other side of the channel, they would use emergency legislation for various reasons, especially because of the war, but later on, in order to deal with various forms of economic instability. And I'm thinking here of Germany of the 1920s and 30s. I'm also thinking here of Belgium. I'm also thinking here of France in the 30s, when the crisis hit, the crisis of 1929. Obviously, Romania. And we can see that there is according to what I have worked so far, there was only one country in Europe during the interwar which never used emergency legislation, and that was Czechoslovakia. But otherwise, it was used everywhere. It was used in order to repress social unrest. It was used to deal with financial crisis. And we can perhaps make some sort of typology of countries which used more emergency legislation than others. And we can see here, for instance, Romania between, I've done some calculations, Romania between 1916, when it was for the first time used the state of siege, up to 1928, the state of siege was declared at least 16 times. And there were areas of the territory of the country which have been constantly under the state of siege. And I'm thinking here of Bessarabia. But then you would have state of siege emerging, being declared back in 1936, and then 1938. And in 1938, you would also have the dictatorship instituted by King Carol. Now, what I'm trying to say is that basically you're going to see, if we're looking at the history of the interwar at least, each time when the state of siege is used, after that, you're going to end up with some form of prolongation of those measures, which can go as far as to turn into a full dissolution of liberal legality, basically, of forms of constitutional law, of forms of constitutional protection, of protections of human rights, and so on and so forth. Now, we might have imagined that after 1945, we have learned the lesson from that. No, but it wasn't the case, and it wasn't the case not only for socialist countries, for obvious reasons, for the socialist countries, but it wasn't the case for other countries either. Emergency legislation was used, as you would know, of course, in France at the end of the 1950s. It was used in Italy. It was used during the troubles within the United Kingdom, and in Germany during the 1970s as well. Now, I'm not saying that emergency legislation is bad. I'm not trying to make that sort of argument. I'm just saying that actually we need to keep an eye on the uses of emergency legislation, because it has, and it comes with that history. And it comes with that history behind it, which basically in some particular contexts can turn quite ugly. And when I'm saying that, I'm also keeping in mind the specific context, general global political context that we have, and we have been having perhaps since 2015. And I'm thinking here of what we call, and what we have has been coined as being populism. This presence or this reenactment of the far right ideologies in Europe and beyond Europe. These tropes of returning to the nation, to blood and soil ideology, and so on and so forth, which are specifically connected and related, and we can discuss about this, to a specific way of understanding the state, citizenship, and as being limited. And obviously, that goes hand in hand with the specific disdain for human rights. For human rights as precisely the rights of human beings, which don't really have any sort of other, character. Now, I'm not going to enter into the polemics related to Giorgio Agamben. I just wanted to say that because Giorgio Agamben, since February 2020, he kept on writing quite a lot on the particular measures that have been taken by the states in order to tackle COVID. And I think he got it completely wrong. And he got it completely wrong. And perhaps I would say that, that there might be some sort of fundamental philosophical problems with his understanding of the exception. But still, I would give him the credit that he was able to point towards an important part of the history of our legal communities and of our law in Europe. And it is this sort of specific practice which stays with us, this practice of suspending the normal process of the law, whatever we mean by the normal process of the law. And we can discuss about this during the question part. But I think it is important to keep an eye on that. And when I'm saying that, I'm saying that there is something, and theorists are presenting it. I'm thinking here of Adam Green, who they are talking about permanent emergencies. Already, Farrajon and Pasquino, they were hinting towards a tendency of what they call embeddedness of emergencies. So basically, these measures that are taken during the times of emergency or of real emergency, let's put it this way, or real threat, they stay with us, and they stay with us because either they are embedded within, I don't know, administrative law, criminal legislation, criminal procedural legislation, and so on and so forth. On one hand, or they can slowly stay with us in the ways in which we interpret and relate to rights. And I think this is a very important thing to consider within the practice at this moment in time, within the practice. The decisions that are going to be given now, they are not going to be effective only for a shorter period of time. They are going to stay with us for later on. And basically, I think that this is something quite important because it shows in this moment of crisis and exception, it shows how actually the legal discourse is shifting. And these shifts are going to stay with us for a long period of time. So to make a long story short, I think that the question is that there are two points that I would want to raise. Is one of the fact that to become aware of perhaps the potential danger which lies within emergency legislation in the light of its history. And the second point would be the fact that emergency is not something which is simply temporary. It is something which has an inertia, and even though theoretically it has been conceived, especially by constitutional theorists, emergency has been conceived as precisely distinct from revolution or distinct from constitutional change, precisely because at the end of the day, emergency legislation means that constitutions cannot be changed during the emergency. My point would be that perhaps we have to think that actually all important changes in societies in Europe took place under periods of crisis. And periods of crisis, at the end of the day, they have been accompanied in a way or another by emergency legislation. So once again, I take an example from Romania, for instance. Before Ceausescu regime fell in the morning of it was 10th of December to 22nd of December 1999, there was a state of emergency declared at the television on the whole territory of the country. 15 minutes later, the socialist regime fell. But I think this is quite important to keep an eye on this. 1938, emergency legislation was passed sine die in February by King Carol II. 3 days later, he announced the instauration of dictatorship. I'm not saying that this sort of things are going to happen. They have to happen. They are bound to happen, and so on and so forth. But what I'm saying is that we are in a particular situation of many crises coming together. And the second point is we have this sort of history of emergency. And it is a difficult task to precisely find the way or the right way of dealing with what we call the COVID at the end of the day, because we are dealing with a health crisis with means which are legal means, and the legal means, they are there with their own history, with their own memorial weight, and this memorial weight and this history might block us from perhaps understanding what is really going on in socio-political medical terms, actually. So, and that's why I think, for instance, that's why I think Agamben got it very wrong, because I think that he cannot really understand, or that there are many people in that camp who can't really understand the real scientifically proved threat of the virus. That's why I found very interesting what Julia was saying about Achille Membe, about the question of necropolitics. There is also this dimension here in which basically, and which living in UK for a while, I recall very well what was the position back in February 2020, when it was said that, we're going to be fine just by washing our hands, and we don't really have to deal with, to do anything. We just need to carry on.
I don't hear you well.
Can you hear me now?
Okay. Yeah. Yes, now at the end.
Up. Am I all right? Okay, so. Okay. Okay, good. So, these are the problems. This is where we are. I just want to end with a quote from Ronald Dworkin, and it is really perhaps something which might sum up a bit, the everything that I wanted to say, and it goes like this: is that just a second, because a judge's duty is to interpret legal history he finds, not to invent a better history. I know that this quote was made in a very different context, and within the intellectual constellation of Dworkin, in which basically he was arguing for the necessity of integrity in the law. But what I'm trying to say here, it's also perhaps, my point would be that we need to keep an eye on this sort of historical presence and this sort of historical weight of emergency legislation. And I think this is, under these conditions, it is a very difficult task that you're having before, and we're all having before us, especially as lawyers, because I think at some point in time we might be facing some serious challenges to liberal legality. So I just stop here.
Yeah, thank you very much for this extremely interesting theory, nuancing all the elements of the emergency and departing with what we have in the calling the classical theory of emergency that I try to say some words. And indeed, maybe Judge Sabato will talk more about Agamben, but his position were quite critical, just to know that he was at the beginning, at the kind of the beginning of this notion. Interesting enough how the notion was developed by Pasquino Pasquale, who is also one of my favorite theories this time in the embedded emergency, and how we try to look, once we have this notion again with us, we try to look at the notion in places where the notion was not searched anymore in academical, in intellectual term. I think this is something quite important. It's something maybe that the pandemic brought to the theory of law, and enrich in this respect the theory of law concerning the emergency. It's a very, very interesting point and presentation. Thank you very much. Now, in the same line, I'm going with a related topic. I'm going to give the floor to my colleague, Professor Bogdan Iancu. So Bogdan Iancu is a professor at the University of Bucharest, Faculty of Political Science. He teaches there EU institutional law, European constitutional law, introduction into fundamental of public international law, and international human rights, including the convention. Professor Iancu was educated mainly in Iași, but also at the Central European University, where he was a student of our former colleague Professor Andra Shayo, and he wrote a lot in different topics of constitutional law, constitutionalism in general, and had several research projects and research visits in different countries, like Heidelberg Institute, in Max Planck Institute in Heidelberg, McGill University, and others. And Bogdan will address the question of state of emergency, COVID-19, and the limits of legal dogmatics. So I'm looking forward for your presentation, Bogdan.
You're muted.
No, can you hear me now? You should be able to hear me now, I think. So I was just thanking Julia for characteristically warm and very generous introduction. Obviously, it can only go downhill from here. So, but since she mentioned Andra Shayo, and I'm also happy that she asked me to speak about the state of emergency, because my presentation will complete the presentation of my dear friend and colleague, Cosmin Cercel. And I will begin to close the circle with a reference to my former dissertation advisor and former colleague of Julia, Andra Shayo, who in a book on constitutionalism co-written with Renata Uitz described international, transnational constitutionalism with the formula referring not to international constitutionalism, sorry, there was a, can you see me now? That's very unfortunate.
No, we see and hear you well.
You see and hear me well, but I cannot see you because, yeah, now I can.
No, it's fine. Okay.
So Andra Shayo mentions the literature, not international constitutionalism as such, but the literature, the treatment of international transnational constitutionalism using the formulation duckbill constitutionalism. Duckbill constitutionalism. What does he mean by that? Namely, that when you have something completely new that challenges your received knowledge of reality, you usually resort to surface similarities. Also, and this is what happened when the English discovered Australia. They discovered the platypus, and the platypus was something completely new. They sent a pelt to London, and the naturalists in London didn't know what to make of it. They called it a duckbill because it has a beak that resembles the bill of a duck. And naturalism, the Royal Museum, they tried to look for stitches to see if that wasn't a beaver upon which a duckbill had been stitched. And they called it a duckbill. It was a platypus. It was something completely new. They didn't know what to make of it. Obviously, just like Shayo didn't try to ironize transnational constitutionalism, I don't mean this as a derision of the gravity of the crisis, because people died, businesses went bankrupt, our lives were turned upside down. So obviously this is a crisis, and it is a crisis the likes of which we have never seen. Now, however, it is a new kind of crisis. It is a different sort of emergency, and we deal with it using the instruments and describing it with the vocabulary that we inherited from the past. Yet it is new. Now, one thing that we know about emergencies, about states of emergency, one main thing is that they are suspensions of regulatory legality during which the executive is entrusted with prerogative powers to deal with the contingency. And then the situation reverts to normality. Romans were, and whatever fetters there are, they're primarily procedural. You can see that from the Roman times. The dictator had 24 lictors. There was no intercession. There was no collegiality. He only appointed the a substitute dictator, the Magister Equitum. We know that he had more lictors than the consuls, that they were empowered to bear battle axes also within the city walls, and that he had absolute imperium. And during this period of dictatorship that took precisely 6 months and not a day longer, or until the emergency was dealt with. And the reason why it took 6 months is that they could get a grasp of the reality. They only fought in the summer. No, they didn't fight in the spring. They didn't fight in the late autumn. They only fought in the summer. So they both controlled the conditions of the emergency and the reality to a certain extent to which emergency applied. And this is the way in which modern constitutionalism deals with emergencies up to nowadays. No, the English with characteristic pragmatic spirit, they didn't even have a legalization of the state of emergency. The executive simply did whatever the executive thought was necessary to do, but at the prime minister's risk, meaning that parliament could indemnify, could adopt a bill of indemnity later on or not, and then the executive would be impeached. The chief executive would be impeached. And this is the kind of regulation that we have used. But the pandemic challenged this somewhat, and I will use only a Romanian example, but perhaps, obviously, I don't have the time to make comparisons. This is an intuition, the beginning of an intuition. Namely, we use the instruments that we had to deal with emergency, namely Article 93, in the Romanian constitution, state of siege, state of emergency can be declared on the basis of a presidential decree for 30 days. If parliament is not in session, it is convened within 48 hours. The parliament has to be asked for authorization of the presidential decree within a period of 5 days. And of course, the article is schematic. So Ordinance 1 per 1999 fleshed out the particular conditions in a specific historic context with reference to a characteristically recognizable emergency, namely the coal miners' assault on Bucharest in the late 90s. And it is obsolete. It was revisited very shortly, but it is obsolete. Constitutional Court didn't review it completely. For example, the ordinance mentions an instrument that doesn't correspond to the ethos of the Constitution as amended, military ordinances. And that comes from the time when the Ministry of Internal Affairs was semi-militarized. Obviously, we had to give that up as a condition of joining NATO and the European Union. So the very terminology military ordinance that's adopted by a civilian minister, the Minister of Internal Affairs, does not correspond to the spirit of our times. And we also used a quasi-emergency instrument, namely the state of alert, that we regulated also in the wake of an actual classical emergency, namely the post-Madrid terror attacks. And as a NATO member, we adopted the Emergency Governmental Ordinance 21 per 2004, which was supposed to be preceding the gravest form, namely the constitutional state of emergency, a lighter, a quasi-emergency form, but regulated in mutatis mutandis symmetric way, namely not the president declares by a presidential decree, but the prime minister by a governmental decision. Now, and what you can note is that the more at the beginning, of course, we treated the sanitary crisis as an emergency. We activated also Article 15, one of the few countries of the Council of Europe who did that. Hastily, I might add, at the beginning of the state of emergency, wisdom counseled that there was no need to do it because the European Court of Human Rights has the wisdom of second-guessing governments when they activate derogations on Article 15, but we did it anyway. So we militarized and gave an executive push to the whole deal. Yet the more time passed, the more it was clearer that the instruments that we used were not well adapted to the situation. So what began as treating the sanitary crisis as an emergency situation ended up with a law that treats it as a sanitary crisis with certain hybrid emergency forms. The Constitutional Court also helped because decisions on the older emergency governmental ordinances realigned the relationship between the branches. But at any rate, what actually happened, so the situation that we have on hand, does not confirm what Schmittian analysis, Clinton-Rossiter constitutional dictatorship, power of the executive power at the expense of the parliament, told us. No? So it's a new kind of situation that to a certain extent we haven't wrapped yet our collective heads around. That's pretty much all I had to say. And if there would be questions, I'll gladly address them in the question time. Thank you.
Thank you very much, Professor Iancu. I think that your intervention was very much in the continuation of the intervention of Professor Cercel. And it was the other side of the coin, indeed. Not only that we can see emergency in a lot of places, embodied emergency, but also, as you said, we don't have yet, and what I try to expose, we don't have yet a theory that is able to cover what we have nowadays. And we have different situations, and maybe it's too early for a theory. Normally, they come afterwards. Maybe for a theory, we need more substance of what will happen in several emergency situations during the pandemic, because the pandemic, as we all know, is not ready yet. And which development will be, or maybe simply that indeed we are not in the situation that was described by none of these classical theorists of the state of emergency, at least for me as well. So it is not only about how we revisit in the convention. We revisit in the convention the rights in the view of the COVID-19, but it also how we are going to revision the theory of emergency in order to apply to concrete cases, but also in order to have this extremely important theory of emergency. And I think that the beginning of this dilemma is only the fact that Schmitt himself, he was a normative theory, so he was thinking to a certain concrete situation. So this is his relationship with the reality was so strong that even if, of course, he's a very, we know him very well, but it was difficult for him to theorize. And afterwards, what happened? It's in the same line with the others main theories that were preoccupied by different parts. I think also now we have a good way to go from theory to practice, and to hear to my colleague Judge Raffaele Sabato. Judge Raffaele Sabato, he's graduated for the famous and renewed University of Naples. Afterwards, he got a master in University of Texas, Austin in the States. He had a career in the judiciary, a very distinguished career in the judiciary, where he arrived to be judge at the Supreme Court of Italy, but also in the cooperation of the High Council of Judiciary with several organisms, including being president of the Consultative Council of the European Judges here in Strasbourg. also, Judge Sabato has a theoretical background and also taught in several universities in Italy and abroad. And I'm looking forward to hear Judge Sabato talking about the European Court in times of emergency, how the court has been working during the pandemic, the derogation under Article 15, and the relevance of health emergency in the application of the convention. Please, you have the floor.
Thank you, Julia. I'm grateful to Professor Motok, my very close colleague here in the European Court of Human Rights, and I'm grateful to Juridice for organizing such an efficient and very, very interesting seminar. I've been happy to hear previous discussions. In the 10 or at most 15 minutes that I can take of your precious time, I will discuss two separate but in some ways connected topics. In one way, just give you in 3 minutes a sort of sample of what the pandemic has meant for the operation of the European Court of Human Rights. So I would say a few words on what has been our procedural experience. And then I would make a very short, but Professor Motok already said many interesting things on this topic in her introduction, on Article 15 of the European Convention, one article that we would wish never to be applied, but nonetheless is always relevant. And so I would connect these two topics by saying that even the court herself in sometimes has experienced and is experiencing a sort of time of emergency. So let me go back to the beginning of the pandemic and to the measures that the Strasbourg court took in order to face the incoming emergency. As it has happened in many countries, the main role has been played by press releases. And this is strange to say for lawyers, but with an immediate press release, number 94 of 2020, then there will be two important ones, 103 and 108, but let me concentrate on the first one. Deadlines, some deadlines were exceptionally suspended. And so this was one first effect. If we only think that the 6 months limit in order to apply is provided for by a rule in the convention, by way of a press release, the European Court of Human Rights decided that that deadline should be suspended. There were, of course, other suspensions that were included in that press release, but those were deadlines that the court assigns to parties in order to file documents, to submit replies, and similar measures. You can imagine that there our surprise is less important. Let me say that from that day on, our activity, as it has happened for the Luxembourg court, for other international courts, and all of the domestic courts, has radically changed. We have been starting, as you well know, to work on the internal level on a remote basis. There were some very scarce references in our rules of court to support that. Then adjustments have been made on the go, I would say. And on the other side, some improvements and some investments also from the financial point of view have been done by the court and by other courts for what concerns electronic communication and electronic and remote management of proceedings. Just to make a long story short, the court, as you well know, holds not so many public hearings, but it does. And those hearings at some point have been managed, has been suspended, first of all, and then later on, when the pandemic was hitting a little bit less, were managed in a remote way. Actually, they were the modalities were hybrid, because the judges were sitting in court and parties would be connected remotely. Let me mention here, as I was mentioning the suspension of the 6 months time limit, one exceptional measure that was taken and which in some ways distinguishes our court from other courts at the domestic level. The European Court of Human Rights, you know, is very strict and very proud of the requirement of a public hearing under Article 6 of the European Convention of Human Rights. So we would think that being impossible to hold the public hearings, these would be substituted by some sort of direct streaming. Well, this was not the case. In some grand chambers that we had with no possibility for the public to get into the court, we kept our usual ex post streaming starting a few hours later than our hearing had taken place. So public control was sort of postponed of a few hours, and you know that this has very strong reasons, because usually very delicate issues are discussed in court, and one thing is that everybody hears the names and details of possible vulnerable parties and other things in presence, and another things that on a streaming, direct streaming, you can learn about people that can suffer serious violations, and they could even be persecuted afterwards. So it was necessary indeed. And one more time, we think of what Julia has said concerning emergency. It was necessary to keep the possibility of editing and having beeps on names and possibly on images of people in hearings held remotely in our court. So these two examples give you the frame of topics that I would have liked to address. Let me finish this first part by mentioning that after that initial part, the court has invested a lot on electronic communications, and now a new e-com investment is underway, and those of you who serve as lawyers or have a chance to have an interplay with the court have noticed that new instructions are being issued, and new possibilities will add to that in the near future. Second part, Article 15. I would just say very quickly that rules concerning emergency are not necessarily in all of the domestic constitutions. For example, my own country's constitution, the Italian constitution, has no rule on state of emergency. The Weimar Republic constitution, the French constitution, the Spanish constitution, for those that I know, on the contrary, have such rules. What the history behind Article 15 teaches us is, in my opinion, very interesting. So I would dwell a few seconds on some historical background. So basically, at the end of the 40s, at the United Nations level, work started on the International Covenant on Civil and Political Rights, which would end in the mid-60s, of course. But then the discussion of the state of emergency, which Professor Motok mentioned, started there. And on this other side of the Atlantic, we were sort of discussing the same issue here in the environment which would then become the Council of Europe. There was a draft of the European movement, and there was a draft Universal Declaration of Human Rights, which did not provide any exceptions in times of emergency. There was an article in the draft of European movement which contained a clause according to which rights were subject only to limitations provided for by the general principles of law recognized by civil nations. You know that this formula will be very fortunate, so to say. So basically, we came to a point in which in 1949, a very famous French intervener in the preparatory works of the convention put forward a proposal that introduced the concept of public order, security, and the concept of necessary in a democratic society, which will then sort of expand, as you well know, to a number of rules in our convention. At this point, the clause which will become Article 15 was drafted, and so you see it's closely linked to other possible limitations on rights and freedoms of other articles of the convention. There was an opposition, I know because I am from Italy, and our delegate, coming from an experience of a country who had, of course, had fascism, said if we introduce such an exception, those forces that violated existing human and fundamental rights in the past might use it, might invoke, I'm reading it, this clause, and we have been used to this over the last 20 years. So I wanted to recall this sort of historical background to see how dangerous and important at the same time Article 15 is. A parallel to Article 15, then we find in the Paris minimum standards of human rights in a state of emergency, but these Paris standards, and this is also very interesting to reflect upon, are very long, and the International Law Commission introduced a number of interesting limitations. For example, a state of emergency under those principles is relevant only if it concerns an entire territory or at least an entire region. And the European Court of Human Rights has taken another way on this concept. I think that Professor Motok already mentioned that. The role of parliaments, state of emergency under those principles should be declared domestically by a parliament and for a pre-established period of time. Of course, you can renew it. But so they are very, very restrictive, which is not the constitutional experience that we have had during COVID, which has been so the experience of our generation, I would say, and we will have to reflect on that over the next few years. So I cannot go longer. I have to conclude. Let me say a few things on how Article 15 is sort of managed by our court, by the Strasbourg court. So basically, it is placed as the first rule after the great list of Declaration of Rights. So before it, we have Article 14 on prohibition on discrimination. So this is the first article after the list, which introduces a sort of bridge between the list and some other procedural and sort of institutional rules. Let me say that the rule in time of war or other public emergency threatening the life of the nation. Which nation? This is a European convention. There are many nations, but you can hear the rhetoric and the history which is behind this rule. Any high contracting party may take measures derogating from its obligations. So there are obligations under this convention to the extent strictly required by the exigencies of the situation. And this is very wide, provided that such measures and so on and so forth are compliant with other obligations of international law. Let me say that this is a rule that we have to frame together with what I said before, the internal limitations that we have in the so-called second and third paragraphs in the other rules, the ones that set standards for rights and freedoms. So basically, the idea is that the fact that in our convention, what does not occur in many constitutions, we have at the same time internal limitation and this sort of generalized possibility of a state of emergency makes a choice necessary. And the court made its choice with this formula. When we have a case, we first examine the internal limitations that we have in each article. So if we take, for example, Article 8, famous respect for private and family life, we go to the second paragraph and we read interferences that might be justified, etc., democratic society, national security, public safety, and the economic well-being of the country, similar to the nation, disorder of crime, protection of health, there we come there. Basically, the court does the following reasoning. Is there a violation if we only apply this limitation or not? If there is a violation, then I will go to the derogation under Article 15, and not vice versa, because otherwise we would not get into connection with society and societal facts, and possibly facts could escape our assessment. So we go first there, and then we come to Article 15. This is very important, and this explains why decisions and judgments on Article 15 they exist, but they are not so frequent. Second and final part, of course, countries have a wide margin of appreciation in assessing whether or not there is a state of emergency, but this does not mean that in case we go to Article 15, the court has no supervision on the requirements in order to declare a derogation. Therefore, second supervision, the internal limits, the strictly necessary, the concept, our former president, Alexandre Sicilianos, although this is not in Article 15, in a conference he held in St. Petersburg over the days of the pandemic, said, probably here we have to transfer the clause of necessity in a democratic society, which is not spelled out clearly in Article 15, but is inherent when we talk of the strict limits or the exigencies of the situation that we have mentioned before. Final remark, really the last one. Let me mention that the three paragraphs that we have in Article 15 are very closely interrelated one to the other. So paragraph 1, the requirements in order to have a state of emergency. Then we go to paragraph 2, which means that there is a procedure. So there is a declaration, We go to paragraph 3. Sorry for a moment. This is better. There is a procedure. So there is a declaration that has to be filed with the Secretary General of the Council of Europe. Let's go back to paragraph 2. And there in paragraph 2, we have rules that are not derogable by way of declaration of a state of exception. And you will not be surprised that we have there not only rules that are obvious, protection of life and from inhuman and degrading treatment, but also rules pertaining to criminal law that are not derogable in times of emergency. Therein included Article 4 of Protocol number 7 on ne bis in idem. This is quite important. Julia, and this is the way I wish to conclude, mentioned that a number of countries made such declaration during the pandemic. About 10, I think. I have them here. I did not count them. But what is interesting is to note that the countries that made those declarations, for example, do not include my own, which has been severely hit at the very start. They do not include France, they do not include Germany, etc. I tried to find what the reason was. And the reason is possibly the fact that there had been criticism in legal scholarship on what had happened on some very sad and very important events in European history in which state of emergencies had been declared, and then the European Court of Human Rights or legal doctrine themselves has believed that there were no requirements. I will only mention one, another very sad but so to say less important one concerning France at the time of Charlie Hebdo. You remember, France was heavily criticized. And I think that this criticism has left something behind that we should remember. So I do not mention other things, but this was an example. So we had Albania, Armenia, Estonia, Latvia, North Macedonia, Moldova, Romania, San Marino, and Serbia. Many of these countries declared around March and withdrew the declarations May, June, September 2020. Some of them, Latvia, for example, or North Macedonia, had the two-step declaration withdrawal and then a new declaration when another wave of the pandemic started with another withdrawal. This is also very interesting. Some of them included the rules that they wanted to be derogated. Some other countries, they did not make specific lists of conventional articles to be derogated, but just submitted to the Secretary General the list of laws. One of them was for sure San Marino, who at the very beginning did not really make a declaration, just wrote a letter and sent the laws. Romania transmitted also military orders, which was interesting for us to read, and I did not have time to discuss with my Romanian colleague the impact, etc. I must finish, and I'm sorry that I took a little more than the time that was allowed, but you see that the topic will probably require some reflection when we will not be so to say, so still nervous, and we will be able to assess all the legal and historical framework of the state of emergency vis-a-vis the European Convention on Human Rights. Thank you.
Thank you very much, Judge Sabato, for the way that you have presented also the functioning of the court during the pandemic. I would say, the good functioning of the court during the pandemic, but also for the overview of the complexity of the situation regarding the emergency in our convention, in relation with some constitutional order, in relation with some our order, and also with the covenant. And indeed, if we don't have yet case law in this regard, we have to be a little bit careful when we discuss about this, but it's sure that, especially regarding my country, we have some cases invoking Article 15, and it will be interesting to see the solution of a court. You rightly said that in the past, countries were criticized by the academia or by international courts or international body like the Human Rights Committee of the International Covenant for Civil and Political Rights, who has a provision regarding the state of emergency. And they were, some of them, more reluctant to adopt this other for historical reason, like your own one. But the other question is the following: what is better, to adopt this provision, to say what you are going to do, or to do without saying? And this is a kind of a more theoretical dilemma, but also policy practical dilemma that a lot of countries face. We are going to see what will happen. Now we are reaching the end of the first panel, and we are looking for the questions for people who are outside our panel, but also questions from the participants in our panel, because I saw that the last conference I moderate with Juridice, speakers were quite shy. They are, I think, in the real life they have more courage, but I don't know why with the webinar they're a little bit more shy. Unfortunately, Professor Churchill had to leave. He told us this at the beginning, that he had classes, so it's not possible for him to be with us anymore. So I don't see any question or comment now.
Julia.
Yeah. Yes,
Matthias. Je voulais saluer tout le monde, car moi aussi je dois partir.
Voilà.
J'ai écouté les interventions jusqu'à celle de Raphaël, et je voulais dire merci à tout le monde, et j'étais très heureux. Merci à toi aussi d'avoir organisé, de m'avoir invité à cette manifestation. C'est important qu'on puisse échanger, même comme ça, de loin, mais c'est précieux. Merci à tous les intervenants. J'ai beaucoup apprécié et c'était très riche. Merci à tous et désolé car je dois vous quitter moi aussi.
Ouais. Merci beaucoup Mathias merci pour tout, pour ton intervention et pour le fait aussi de nous avoir écoutés. Merci.
Merci, au revoir.
Au revoir.
Au revoir. So.
I would perhaps use the opportunity to ask a question regarding these differences between states in whether declaring that they're using Article 15 or not. Because the measures, the underlying situation is the same, and the measures are also largely similar, so they cannot be both right. I would personally also prefer to have let's say, restrictions assumed to be part of Article 15, because that would be an acknowledgement that is really something extraordinary, so it's meant to come back to normal, as opposed to stretching the convention otherwise and to argue that the current form of the rest of the articles actually can accommodate these massive restrictions as they are. So there are basically two aspects to the situation. One, in terms of principle, I think it's preferable to place everything under the derogatory regime because it shows it's exceptional. And secondly, is this issue that not everybody can have right at the same time. So there are some states, based on the same underlying facts, considering that they cannot place themselves under the rest of the convention, while others obviously had a different view. And I would appreciate your views on that.
Yeah,
I mean,
thank you very much, Mr. Bondok. I think that this was a question for
Mr. Sabato.
for Judge Sabato. Yeah, this was a comment and a question.
Indeed.
And afterwards, you are going to talk yourself about this theme again. Please, Raffaele.
Yes. As I was probably mentioning before, and this is probably the best way to shortly answer to Mr. Bondok, the distinction is between sort of those countries that feared that something could happen with the court because of complaints, and those other countries that sort of kept their blood cold in that respect, and those that probably decided to just do it anyway. And as I tried to show, they did it in a sort of way in saying, these are the laws. I don't even say that I want to derogate. There was one country, I will not mention it, that did not say. Some listed the derogations. Albania, Estonia. Estonia had probably the longest list, and was very interesting to read it. But I will make a joke. Just to make something that is usually heavy and as I said, makes us very nervous. And unfortunately, my country has been severely hit, and yours are as well these days. I was noticing that Article 12, right to marry, has no second paragraph. There's no possibility of an internal limitation. But in my country, at least, which was the first one, then probably the other ones had a way to arrange marriages in a remote way, or with somebody going home of the newlyweds and marrying them. For a month or so, there were no instructions on how to marry. Everybody was at home, and this was not urgent. It was, of course, urgent. Probably somebody will have married that we don't know yet, but the legal, so to say, conclusion was then it would be better to have a derogation. No country listed Article 12 nonetheless among the rules that they wanted to derogate. But the joke has some serious part, and we saw, probably in the future, as I said, we will reflect. And thank you for this question, which was very interesting.
Thank you. You are on mute, Ms. Motok. You are on mute, Julia.
Yeah, thank you very much. So I said I thank Raffaele. I just said that we are quite late because we are after 2 hours from the beginning of the conference. I will not joke that this is Romanian time of doing things. We like to discuss, and it's for me is more difficult to cut the speakers online. That is in the face-to-face life is difficult, but online it's even more difficult. So I will start now the second panel. And the second panel will start with Lucian Bondok, who is a managing partner of the Bondok and Associații, leading for many years the Bucharest-based corporate and competition practice groups of top-level international law firms, has experience in dealing with complex, sensitive corporate competition and investment projects, in different consumer products, retail, pharmaceutical, energy, and natural resources. But I have to say that at the same time, Mr. Bondoc, he's writing in the press on several articles relating policies, law, more theoretical and more policies oriented things that the more technical part that he's doing like a lawyer. You have the floor, Lucian.
Many thanks, Julia. I think actually I also crossed Mr. Guillaumard at École Nationale d'Administration, where he was delivering some trainings at the time on law and public policy. Actually, precisely my intervention of today is focused on is more on a public policy efficiency standpoint. Basically, to what extent the human rights protection system was adapted in practice to actually what happened. And I'm referring more particularly to Article 15, which was already presented by Judge Sabato. And Article 15, as it was just mentioned, basically allows for derogation from the convention in basically under three conditions. The first one is it has to be a type of war or other public emergency threatening the life of the nation. The second one is the measures taken in response to that must not go beyond the extent strictly required by the exigencies of the situation. And there is a third condition: the measures must not be inconsistent with the state's other obligations under international law. I will just refer to the first two with some additional elements, with some specifications building on the previous presentations. And then I will go to the main point of I'm trying to make. Basically, if we are looking at these first two conditions of Article 15, the concept of other public emergency threatening the life of the nation was mainly applied, as Ms. Motoko was already mentioning, and Mr. Sabato, in relation to situations of civil unrest, terrorism, like the UK, Ireland case, Turkey, also the Greek case. And on those occasions, it was clarified as, for instance, that the measures related to such events can be maintained for years without losing the emergency nature. They can also concern just regions, but still be deemed as threatening the life of the entire nation, and these type of aspects. All useful clarifications, and that could also be relevant for COVID-19 very well, as we know. Regarding the type of measures that can be taken, which is the second condition, as Ms. Motoko was mentioning, a wide margin of appreciation is left to the member states. They are considered closer to the ground, and this is expressly recognized by the court in some cases, and also in some reports and recommendations of the Parliamentary Assembly of the Council of Europe. On the other hand, as it was mentioned a bit earlier by Mr. Sabato, this freedom is not absolute, and there are some principles that need to be observed. And the case law, basically, the principles that emerge from case law include the fact that such measures should be adopted at the level of the law, and basically should be a reasonable and objective one. There should be a limitation to what is necessary. There should be a proportionality. There should be safeguards, the possibility to challenge in court. There should be no discrimination on the account of gender, race, group, and so on. And there should be a practicable access to justice for checking the observance of these type of principles, minimum duration, and so on and so forth. All these are also very important and are also relevant for COVID-19. However, and here I'm going to the main point I'm trying to make, is that what this actually means in practice when we are talking about COVID-19, how they can be assessed. And I think as a mechanism which is part of the checks and balances system, the human rights protection mechanism should basically be able to tick the box on like 5 aspects. One, it should have sufficient data to assess those conditions. Secondly, it should have the technical capabilities to actually assess them, to do the real assessment, the actual assessment behind, and this can be internal or through contracted external experts. Another condition, I think, there should be a reasonable objective benchmark when I'm assessing proportionality versus what, for instance, or necessity versus what. There should be procedures in place that allow for prompt and consistent rulings on the matter. And finally, there should be an efficient sanctioning. And I think that on all these 5 aspects, there are some difficulties in cases like the COVID-19 one. And this is so because pandemic events involving totally new viruses, as it is the case of COVID-19, have a lot of specificities. A first specificity, for instance, is that any pandemic involves basically 4 phases, not just one. And there is a dynamic in time. The first phase is where we don't know almost anything. And when you have a new virus, this is actually the case. So you have a period where actually you do not know whether the life of the nation is threatened, but of course it would be irresponsible.
I think that that he has a problem with the internet connection. We are going to wait to be reestablished. Otherwise, yeah, yes. Maybe maybe we wait other 1-2 minutes and we start, and he will come back, and he will continue in order not to waste time. What do you think, Raluca?
Maybe we should wait for 1 or 2 more
Okay,
minutes.
we are going. Yes, we are waiting for.
Yeah.
Yes.
Apologies, I don't know what happened.
Yes.
I'm back
Please
online.
continue.
I don't know at what point you stopped hearing me, because I was just starting to say that there are a lot of specificities of the COVID-19 pandemic, and that there are 4 phases of it. One is this is one specificity. The first phase is that at the beginning we don't know almost anything. So actually we do not know whether the life of the nation is threatened, because the virus is unknown by definition. And it's just that it's irresponsible not to test that in practice. So one needs to be prudent. But in the first phase, actually, it's we cannot actually meet that test normally. It's just that prudency is the norm. Of course, if someone is abusing of that, there should be very harsh sanctions subsequently. In the second phase, there are gradually more data piling up. So there is more visibility on actually what is going on. The third phase is where we start to have efficient access to basically access to efficient drugs and vaccines. And this is also a gradual process, as opposed to just treating with pre-existing drugs which are symptomatic. They were designed for something else. And the fourth phase is where the pandemic is actually controlled. And if we are looking at the current system, of course, the European Court of Human Rights recognizes the fact that derogations should be assessed at the time based on the information existing at the time of their adoption. But for the time being, we don't really have this dynamic recognized, and this fluctuation of time, and the fact that the test should increase basically with the time and the access to additional information. And I think this is important also because it prevents inertias the difficulty in changing positions already adopted, even if the positions in question were adopted at a time where the information has been far more scarce. Another specificity is that in pandemic situations, there is a far stronger link between the two conditions, the first two conditions of Article 15. For instance, if we consider that there is a public emergency threatening the life of the nation, I believe this limits the possibility to assess the proportionality of the measures, because the underlying issue of both is the medical seriousness. So they are actually far more linked than in the cases with which the court has previously dealt until now, like where you have a terrorist situation, and then you are comparing and assessing infringement of rights or limitations of rights versus that. This time, in case of new viruses, such as COVID-19, both conditions are far more linked. Thirdly, the third specificity is that the technical capabilities are far more concentrated at the level on the side of the state. By definition, we are dealing with something new, which means what? At the very beginning, there is no expert in the entire world. No one is really expert at this, although a lot of people are studying it. Then there is a bit of a kind of expertise emerging, and usually this is concentrated at the level of the state. And this means what in practice? That is very difficult for someone externally to actually check and challenge in court the underlying assumptions, because it's very hard to find experts up to the job, either because of informal hierarchies in the medical systems, or simply because there is no such an expert. There are smaller countries that even to date, they can arguably do not have a real expert in this type of matters. So there is also an effect of contagion between countries. So this is another aspect to consider. Another specificity, the fourth one, would be that there is a clear conflict emerging between the rights of different subjects. And this is at large scale. And I'm not talking about issues resulting directly from limitation measures, but we are also talking about indirect inherent discrimination. Different categories, for instance, regarding COVID-19, different categories of citizens are affected differently depending on the age or their medical condition. Citizens affected by other diseases may be more vulnerable, but there might be also citizens that are very exposed to their pre-existing conditions, and those pre-existing conditions are no longer a priority for the medical system because it's over-focused on COVID-19. And I think Ms. Devescu will develop this aspect on the effects on the health of other subjects. There are some professions which are not affected at all, and others which are affected to the point of becoming bankrupt. And here it's also regarding the right to property. This is also an inherent discrimination in the system. Basically, this doesn't hit everybody in the same way at all. Children have different access to internet, therefore different access to education during pandemic situations. Isolation is relevant in a different manner, depending on your own family situation, your own mental health, location, and so on. Restrictions affect professionally more young people than well-formed and mature workers. Another aspect to consider is that there are many rights that can be affected very badly on medium term of other subjects. So basically, it's difficult to measure and to compare. The advantage is the balance between the short term versus the long term. In terms of, for instance, the percentage of people that could be affected in a second step, mental illnesses, cumulative effect of poverty could be far greater in the end. And also there are many exceptions of the measures and overall relaxations of the measures where technically, which are basically motivated economically. They are not really motivated on human rights considerations or balancing. It's simply the economy needs to run in a certain manner, and this also creates discrimination and difference of revenues and of effects on many other areas on basically the citizens of the same country. And regarding also the elements of a public policy to work, there is actually no clear benchmark in such situations. what are we talking about as a benchmark? How many deaths are acceptable in the current world? Are we regarding this on the short term or on the long term? What are the effects in the medical system, in the mental health, in the economics, 3 or 5 years from now? And when you are having this issue of benchmark, if you are going on the idea that there is no price for a life, and even one life is too much, the problem is how you are balancing this versus the effects of the limitations of the rights at the scale of a nation. And not only on the short term, in 1 month or 2 months, but in 2, 3, or 4 years. If in 6 months of restrictions, the public debt is going up 20%. I'm not saying this in an idea that COVID-19 is nothing and so on. I'm one of those Romanians that believe it's a very serious disease. I'm vaccinated and so on. It's just that these are aspects that simply limit in practice the way you can actually assess the very basis, the presumptions of applying human rights. And that generate difficulties in practice for courts to also check these type of aspects in real terms. So basically, as a result of these specificities, the effective access to justice is actually affected in mainly 5 manners. Duration of many restriction measures is such that they cannot be challenged in due course. And in Romania, we had this situation, actually we still have it, but in June, there was a Constitutional Court decision that said precisely that the government should adopt decisions and mechanisms allowing for such measures to be challenged timely, because otherwise still extending the measures for 30 days didn't give sufficient time under the normal procedures to challenge them. But the issue is that even if you challenge them, there could be situations where it is easy to assess an excessive limitation of human right. And for instance, the Maltese case was a good example in that respect, because there we had a situation where an immigrant was kept in isolation for 7 weeks, and then he was moved to a population of people suspected to have COVID-19 pending a further analysis of his case. So basically his life was put at risk, while after 7 weeks, he was clearly not an issue. He was not in the same situation as the others. But my point is that there are many, many other situations where this type of assessments cannot be actually made by courts, really relying on clear data, really being able to assess what proportional means and whether the underlying presumptions of the measures are actually fully correct, and also how they balance in their dynamic in time.
Okay, thank you.
Yeah.
Thank you very much. Thank you very much. Very interesting presentation indeed. And also you touch not only aspects of Article 15, but how this will be applied in practice. And again, we come back to a theme that I mentioned briefly, but I think is not enough mentioned, especially in our countries, what the vulnerable people, how they cope with the pandemic, how this affect their basic rights, and not only the right to health, but also the right to educations and other rights converged. So this is a good, I think, a good way to build a bridge between what my colleagues have spoken before and the practical field. And now we are going to go to a theme which is central also to the pandemic with Professor Raluca Bercea. Professor Raluca Bercea is professor at the West University in Timișoara, and she's teaching human rights, comparative law, European law. Professor Bercea, she's also a lawyer with the Timiș Bar and a certificate trainer with the health program of the Council of Europe. She's also visiting professor at Paris Panthéon-Sorbonne and Udine University, and she will talk about the sanitary crisis as a freedom of speech crisis. Raluca, please, you have the floor.
Good evening. Thank you very much for this kind introduction. Please allow me to express my gratitude for the invitation to speak at this conference. I have recently had the chance to reflect on the freedom of expression and also on the limitation thereof, either in interaction with European magistrates within the EJTN trainings or as a representative of the National Association of the Romanian Bars within the Trial Project, which is a project that mainly focuses on trust, independence, impartiality, accountability of the legal professionals. And as you can imagine, freedom of speech has been one of the hottest points in that project. I will not try to explain the relevance of the topic that I have chosen. I will not insist on the importance of the freedom of expression. It is common knowledge that we are all dealing with one of the essential foundations of our democratic societies. I would rather inquire whether the sanitary crisis is a freedom of expression crisis as well. And I think that it is worthy mentioning that we have already spoken about possible deterioration of freedom of expression in Europe already in early 2019, before the sanitary crisis, in fact. And the situation obviously grew worse in the past year and a half. Reports have stated that journalists covering the pandemic in several countries were facing a variety of sanctions amounting under some newly enacted laws to prison. Also reports of cases of journalists who were prevented from attending press conferences were made, or reports of journalists that were prevented from obtaining information from health authorities. Probably against this background, as a response, the Committee of Ministers of the Council of Europe issued guidelines on protecting freedom of expression and information during the pandemic. While reading the guidelines, maybe three elements have caught my attention that underlined had the power to underline the stakes of the sanitary crisis and also to some extent the standards to apply thereon. In the guidelines, rumors and misinformation were recognized, acknowledged as likely to cause harm to the public order and public health on the one hand. And on account of that, the media and the journalists were expected to abide by the highest professional and ethical standards. On the other hand, states were warned to avoid measures that were vaguely worded or unforeseeable in results, or that are likely to lead to over-criminalization. We know that in principle, Article 10 provides us with a broad level of protection. Almost all kinds of speeches are highly protected with only a few exceptions. And we also can qualify the pandemic context as a matter of public importance. Therefore, the debate on the pandemic itself should highly and broadly be protected. If we try to make a legal analysis, I think that we are maybe followed by students that would find it interesting to get to the basic legal analysis. If we are thinking about the three components of freedom of expression, I think that the right to hold an opinion has remained untouched by the pandemic because probably it almost amounts to an absolute right. But if we are thinking, on the other hand, of the right to receive information, to impart information and ideas, there is a tension there between the demand for quick, complete, reliable information on the one hand, and the danger to be misinformed, disinformed, being subject to hate speech. And the state, in fact, all around Europe had to somehow strike a balance between these tensionate poles. The academia also tried to interpret the content of the general obligations on behalf of the states so that they include new elements typically relevant within the health crisis. For instance, is there an obligation for the states, parties to the convention, to keep the public educated and informed about the pandemic? If so, to what extent? Should there be a symmetry of information provided to the public as compared to the information that is in the possession of the public authorities. Should the states ensure access to information to healthcare professionals, and the standards of this information, should they be equivalent to the global level? In any case, probably all the academia have agreed upon the fact that the measures that tried to reduce the information, the flow of information to official communications, which were measures quite spread within Europe, would lead to censorship and would be disproportionate. So we know that there is a negative obligation quite well qualified on behalf of the states from this point of view. And this brings me to the discussion of that is probably the most important and relevant here concerning the status of restrictions that were brought to freedom of expression. Of course, some restrictions have been needed and justified as exceptional circumstances require exceptional measures. This is, again, common knowledge. And here, the need was to avoid spreading conspiracy theories, false alerts, and so on and so forth. But I think that several types of restrictions can be dealt with, and from several points of view. I was first thinking about Article 17, and I was quite quickly came to my mind the case of Molnar against Romania, and probably the abuse of right that is dealt with by Article 17 can be applied in cases in which purportedly, in which persons purportedly spread false news in order to breach other persons' rights, Article 8, Article 9, that might activate Article 17. At the same time, Article 17 speaks to the states as well, who should not abuse of their powers to restrict rights. It was mentioned already that the court has dealt with the abuse of the right of individual application, and this is closely linked to the mechanism of Article 17 itself. Of course, the relevant general limitation today appears to be the one that has already been mentioned, the derogation allowed by Article 15, and we know that 10 states considered the sanitary crisis as a public emergency threatening the life of the nation. Interestingly enough, none of them expressly derogated with regards to Article 10. And here I link to what Judge Sabato mentioned, that there have been several ways in which the declarations have been drafted. In some cases, the states did not indicate the precise qualification of the derogation with regards to the rights mentioned in the convention. In other cases, and they only attached probably to the not verbale communicated to the Council of Europe, the lists of rights that were mentioned in the declarations, in the national declarations of the states of emergency. And while reading the national statutes, the national decrees, one can find that, for instance, freedom of expression is expressly provided as being limited in the case of Armenia. However, there is no express mention as an article that will be derogated upon. The derogation itself was very badly understood in several cases. I'm thinking about the case of Romania. Firstly, where the derogation was understood as giving up or suspending the human rights within the national territory, with the consequence that the court will not be able to control the measures adopted by the state, given the wide margin of appreciation that those enjoy. Of course, there has also been a charitable interpretation to this mechanism, and persons explaining that the derogation was necessary to keep the authorities accountable and to also put a limit on the granting of new extensive powers to the executive. If we are describing the discourse surrounding the derogation made by Romania under Article 15, only rarely was it obvious that those who commented on the derogation noticed that the derogation continues to be narrowly construed, have a clear legal basis, needs to be strictly necessary to bring public emergency to a close. So there has been a speech, a type of speech surrounding the derogation by Romania under Article 15 that is debatable as such. Of course, the most severe and common interference with Article 10 was represented by the obligation imposed by the states on media to publish only official information. This has happened in several countries. And here the question is whether the censorship touches the very essence of the right, case in which, of course, we will not analyze the second paragraph of Article 10. If, however, we think of the other situations and make the test provided by Article 10, issues have been raised at least concerning the condition of the interference being provided by law and as far as proportionality is concerned. The first condition related to in practice to statutes that were newly enacted, sometimes to emergency legislation. And we know that the court treats this condition of being provided by law as an autonomous concept. And in very many cases, it was unforeseeable. The consequences of these acts were difficult to foresee. And there was no established judicial practice to clear the concept as well. So there might be a problem from this point of view as well. In terms of proportionality, there are three elements that are worth mentioning. First of all, the checks and balances, the fact that in such a context, the media, the medical professionals, the civil society should have the right to criticize the authorities and also to scrutinize their response to the crisis. One should also think of the chilling effect of the very energetic measures that have been taken in some states. I was referring to the criminal sanctions that were encountered by journalists, and probably the third and interesting point should be made concerning the whistleblowers. Of course, one question should be whether the sanitary officials concerned by the specific restriction imposed on are concerned by the very specific restriction imposed on those carrying duties and responsibilities. In other words, whether they should be considered or not as being civil servants. Interestingly, in very many situations, relevant connections have been made between a possible unconventional treatment of the whistleblowers in some states and the rule of law crisis in those states. And I'm thinking about academia writing about the treatment of whistleblowers in Poland or in Hungary and associating the two crises, if I may say so. And there we have a case that might be important, and probably it will be interesting to see whether the standards that the court assessed in that case will be applied to the freedom of expression as well. I'm thinking about Gavlik against Liechtenstein, a case that was adjudicated in February 2021, and where to some extent the case law of the court changes a little bit as far as the whistleblowers are concerned. I will only take probably 2 minutes to refer to the freedom of expression online. I think that Judge Motok referred at the beginning to a case that was already communicated on Article 10. Probably, if I am correct, it is Avagyan against Russia, where we have a problem concerning the freedom of expression of the applicant who posted a comment on Instagram, an online comment, stating that no real case of COVID existed in a specific region of Russia, and the result was a fine amounting probably to 400 euros. There will be a case in which we will have a judgment on Article 10. And then we will see the standards, the way in which the court will appreciate them within the sanitary crisis. This specific type of debate, how is freedom of expression affected when online, should be probably discussed from the point of view of the states, two types of actors, the states on the one hand, and then the companies on the other. I will only give two examples from the point of view of the states. Various states in which newly enacted legislation impose an obligation on owners of internet news outlets to prevent the dissemination of harmful information online. Or the case of Romania, where the authorities are allowed by the decree to remove content and block websites where this content provides false information. Obviously, this triggers consequences and changes in the behavior of the companies, and the companies are reported to be under significant pressure to ensure that they do not enable harmful public health disinformation to circulate on their platforms. They are taking an unusually aggressive approach in removing misinformation, and this in a context in which health measures such as social distancing have led them to drastically reduce their content moderation workforce, which means that there is an increase in the use of tools of automation and obviously an increased risk to mistakes. All in all, social media and search engine companies have enormous impact on public discourse and on the rights of individuals. And I will finish by trying to give a few elements of facts that probably might, an example that probably might help us understand the stake of the crisis of freedom of expression and the synergies therein. And I'm referring again to the Romanian example. We have the decree on the state of emergency in mid-March, and already at the beginning of May, 15 sites that were set to broadcast fake information closed by the authorities. Most of them reopened immediately. They acquired 5 to 7 times more readers than before. The information spread 10 times more rapidly on those sites that the authorities' information, which means that to some extent authoritarian measures only legitimized the discourse that in fact the authorities wanted to be interfered with and reduced. I will promise to finish by giving this example. The closing of supermarkets, which proved to be a fake news, appearing on the 15th of March 2020, knew immediately more than 30,000 distributions, which means that, however drastic, or maybe on account of them being very drastic, the measures in fact were not able to control the spread of false information and disinformation. Quite on the contrary, they only triggered the crisis of the freedom of speech. Thank you very much. I hope I have not abused of my rights and time.
Yeah, thank you very much. Thank you very much, Professor Bercea, for this brilliant presentation that you have used us in the past as well. Indeed, Article 10 is another crucial article in relationship with this crisis, and we have different facts, and I will underline here especially the question of the fake news, because the court has not dealt yet with this problem. Indeed, if you compare the way that our court deals with Article 10 with, for instance, the US court, but their freedom of expression is differently defined, you are going to see some differences, but still our cases are in general in favor of Article 10, and even if we balance, when we balance with Article 8 in line with the famous von Hanover case, we see a certain tendency of the court, as we have written in our case law, to give a very for freedom of expression, a very large way of manifestation. We are let's see in which direction our case law will go. You already mentioned some of our cases that were communicated, and now soon we will have some answer to this question sooner than before. Our last speaker is lawyer Tatiana Șoldănescu. Lawyer Tatiana Șoldănescu, she's a lawyer at Livescu and Association, and she will talk about COVID-19 impact on the right to health and life of the non-COVID-19 patient from the perspective of access to medical services, a very important topic. I have to say that Tatiana, she's a young lawyer, but she's specialized in European court and in issues related to human rights in general. So we are happy to have her here as a representative of the young generation of lawyers. Tatiana, you have the floor.
Thank you so much. Please allow me to thank you first for the invitation to take part in this event and for allowing me to take the place of my colleague Monica Livescu, who unfortunately couldn't be with us today. I hope I can represent her well, and because it would have been a misfortune to not present this topic that we both think is of really huge importance nowadays. I have also prepared a PowerPoint presentation. I hope you can see it. Please allow me first to present the plan of my presentation. In the introductory part, I will try to express the necessity of this topic, and in order to understand the importance of the topic, I will briefly present statistics results to illustrate the impact that the COVID-19 had on access to medical care for non-COVID-19 patients. In the first part, I will analyze the case law of the European Court of Human Rights and the relevant international instruments. For the second part, we have prepared a case study on the Romanian legislation during the COVID-19 pandemic and its compliance with health protection standards. And last but not least, we will have some concluding remarks. So let's start with the first part. As you can see on the screen, we have tried to identify 3 parameters that should define the governance norms. And that would be legitimacy, transparency, and accountability. We believe that all the restrictive measures should respect these parameters. The legitimacy would mean that each restrictive measure should be convincing on their necessity, and it should have ongoing assessment in order for everyone to understand why that particular restrictive measure is necessary. The second parameter identified was transparency. That would mean everyone should know from the public authorities why such a measure would be necessary, what are the protective measures for that restrictive measures, and in what way it is performed, and what are the remedies against this restriction. And last but not least, a very important parameter would be accountability. Each restrictive measure should have the opportunity to be challenged by everyone who is affected by that measure. Moving on, as I have stated in the introduction, and as Judge Motok started this debate, I'm going to present some numbers that would justify the necessity to treat this subject. So we have read a lot of studies and statistics that were made. You can see on the screen just some of the most important results of these studies. And I'm pretty sure that you can see the numbers, the high numbers that resulted from these studies. These high numbers suggest how much the COVID-19 pandemic has affected patients, people who didn't suffer from COVID-19, but have other health problems that require medical attention. For example, 53% of the participating countries in one of these surveys said that there was a disruption in medical services for the treatment of hypertension. 80% of doctors reported that the mental health of their patients worsened during the COVID-19 pandemic. So it is clear that these statistics confirm the importance of the analysis of the effects of limiting the access to medical services for the chronically ill during the pandemic. And it also shows that the authorities might have neglected non-COVID-19 patients from the desire to limit the spread of COVID-19. Moving on to the first main part of this presentation, we are going to analyze a little bit the case law of the European Court of Human Rights on the right to health. We all know that the convention itself does not expressly guarantee this right per se, but of course it is a right that derives from other rights that we are also going to analyze further. The case law of the European Court on the right to health refers quite frequently to other international instruments that help the court to decide in a way or another. These international instruments, as you can see on the screen, are the recommendations of the Committee of Ministers in the field of health, the Convention for the Protection of Individuals with regard to automatic processing of personal data, the European Social Charter on Health. But also, it is important to know that when an individual complains on his breach or violation of the right to health, he usually argues on Article 2, 3, 8, 13, and 14 of the Convention, and why not Protocol 12. For the purposes of this presentation, we are not gonna try to talk about all of them because that would exceed the time. So we are going to analyze the Article 2, which guarantees the right to life. As you can see on the screen, when analyzing a complaint based on Article 2, the court will verify the two limbs of this article, which are the substantive and the procedural one, and will also analyze if the state has fulfilled its negative and positive obligations that were established in the case law of the court, for example, in the case Lopez de Sousa Fernandes versus Portugal, or Calvelli and Chilio versus Italy. Just to name these obligations, the negative obligation of a state would be that that state must not interfere with a person's health unless there is a justification in compliance with the convention. So the state has to refrain from actions or omissions that would endanger life or put the health of people in serious danger. The positive obligations of the state are both of substantive and procedural nature. The substantive obligations would mean that the state should take measures to protect the health of people, enact regulations requiring hospitals to take appropriate measures to protect the lives of their patients, including to exercise control over the implementation of measures. The procedural obligation would mean that the state must establish an effective, independent judicial system so that the cause of patients' deaths would be properly analyzed. Moving on to the analysis of the Article 2 in the case of the court, it was interesting to find out that the court has accepted that state liability can be engaged based on the substantive aspect of Article 2, in particular where, for example, the life of a particular patient is endangered by depriving him of access to life-saving emergency treatment, and where a systemic or structural dysfunction in hospital services leads to a patient being deprived of access to life-saving emergency treatment, and also the authorities are aware that they should have applied that medical treatment but failed to do so. So in order for a case to fall into the category of those who involve both medical negligence and those in which the patient is deprived of access to emergency treatment, in the case law of the European Court, we have found out that certain factors are to be met, and they are also listed on the screen. I'm only gonna briefly go through them. The acts and omissions of the healthcare providers must overcome a simple medical error or negligence. So the deprivation of the patient of the emergency medical treatment must be done especially when it is known that the person's life is at risk. The dysfunction in question must be objectively and realistically categorized as systemic and structural. There must be a link between the dysfunction referred to and the damage suffered by the patient. And last but not least, the dysfunction in question must have resulted from the state's failure to fulfill its obligations to provide a regulatory framework in the broad sense mentioned above. On the next slide, we have selected some judgments against Romania that are of particular interest because we have identified some general principles that we actually recommend the public authorities to keep in mind when taking measures that might lead to limitations to the right to health of people that are not COVID patients. So in the first case selected, we have identified the following general principles. You can see on the screen the exact paragraphs, but I have extracted the principles so it is easier for the people who are watching us to understand. The following principles would be that the acts and omissions of the authorities in the field of healthcare policy may, in certain circumstances, engage responsibility under Article 2. We shouldn't forget the principle of practical and effective rights. So the right to health should be practical and effective and not just theoretical and illusory. The authorities should do everything that is expected of them related to medical treatment. The state's obligations regarding appropriate health care is one of means and not result. I think this is a very important distinction to be made, that the state has an obligation of means and not of result. In the following cases, some other principles we have identified some other principles that, for example, in the first case that you can see on the slide, the court established that states have an obligation to provide prisoners with medical care. In the next case, the court actually said something really interesting, that the state has to take appropriate measures, especially when the capacity of patients to take care of themselves is limited, and that the court has to assess if the state had done all that was necessary to prevent the applicant's life from being put at risk by providing him or her with adequate medical care in a timely manner. In the last case that we have selected, which is you can see a long extract from it. The following principles have been identified: that that Article 2 of the Convention may come into play even though the person whose right to life was allegedly breached did not die, which means that Article 2 guarantees the right to health. The denial of health care to the general population may fall under the second article of the Convention. And even if the state has failed to apply one particular measure provided by the domestic law, it may still fulfill its positive obligation by other means, by applying, for example, other medical treatment. This would be the part referring to the case law of the court. As I've said in the introductory part, I'm also going briefly into the relevant international instruments that also the court, when deciding on its cases, takes into account. And we have, for example, the International Covenant on Economic, Social and Cultural Rights. We have Article 12 from this international instrument, which was explained in the concluding observations of the Committee on Economic, Social and Cultural Rights, um, uh, to imply the obligation of states to make available healthcare units, goods and services in sufficient quantity and accessible to all, both physically, economically, and without discrimination. We have also the International Covenant on Civil and Political Rights. We have Article 6 from this international instrument, which also states the right to health. But even more than this, we also have Article 26 from this international instrument that guarantees the right to equality and not to be subject to discrimination, which we believe that it is crucial for the exercise of the right to health. We believe that health facilities, goods and services must be accessible to all, which maybe during the pandemic and even now wasn't the case. Maybe only the COVID-19 patients had access when they wanted to medical care, and other patients suffering from other diseases couldn't benefit from health care. So, and last but not least, we have also the European Convention for the Protection of Human Rights and Human Dignity against the Applications of Biology and Medicine, also known as the Oviedo Convention. And briefly, I'm gonna go through the non-binding international instruments that also set guidelines that the public authorities should keep in mind when taking health-related decisions. We have the European Charter of Patients' Rights. We have the Syracuse Principles, the Lisbon Declaration on the Rights of Patients, and the Declaration on Patient-Centered Healthcare enacted by the International Alliance of Patient Organizations. All of them provide the right to health, and they describe this right in certain manners. It is important to emphasize at this point that we believe that patients' rights may have been subject to restrictions when imperative requirements of general interest demand so, but only if they comply with the principles of necessity, proportionality, and adequacy to achieve that objective, and when these measures are applied without discrimination. And for the last part of this presentation, we are going to analyze the case of Romanian legislation during the COVID-19 pandemic and its compliance with health protection standards. You can see on the screen the most important norms in the Romanian legislation that provide for the right to health. And for the second part of this case analysis, we are going to analyze the administrative decisions and the norms that were taken during the pandemic. We have identified 16 orders of the Minister of Health that were issued related to the pandemic, and that actually limited the access of non-COVID-19 patients to hospitals. So we believe that the principles resulting from the court's case law that we have cited before should and could have been applied in analyzing the situations in which people with other chronic diseases were deprived of access to medical service during the time when these orders of the Minister of Health were in force. For example, we have had in this during this pandemic certain administrative decisions, for example, stating that.
Tatiana, sorry, you should conclude because we are almost.
You can see them on the screen. They are very detailed. The measures are very detailed. So I'm just going to conclude with these conclusions. We believe that the enactment of any normative act during the pandemic in Romania triggered by the COVID-19 crisis should have taken into account the landmarks expressed before, in order to avoid the violation of fundamental rights such as the right to life and non-discrimination for all patients, and that all the public authorities should have kept in mind the preamble of the Universal Declaration of Human Rights, to which this conference is dedicated, and which very important phrases from the preamble are shown on the screen, and that these guidelines should have been kept in mind, and maybe will be kept in mind by the authorities in the future, to avoid any other limitations to the right to health of people that didn't suffer from COVID-19. Thank you so much for your attention, and I would also like to congratulate all the speakers before me for all the knowledge that they passed on and for very interesting presentations.
Thank you very much, Tatiana. It was really fascinating presentation because of the topic, but also because you put together non-binding instrument, binding instrument, and also Romanian legislation in this respect, and of course the convention. I think it is an issue. It will be more and more an issue at the domestic level, and at a certain moment at the level of the court. Indeed, you have mentioned that today we celebrate the United Nations General Assembly adoption and proclamation on the 10th September 1948 of the Universal Declaration of Human Rights. It's an extremely important day all over the world. So it was important also for us in Romania to have this webinar, even if it was a very long one. But I think it was fruitful and rewarding for those who had the patience to listen to us. And I thank very much all the speakers that some of them they have to leave, for their excellent presentation, very rich, very complex. It was a fantastic discussion, and also to the participant and indeed to our media partner, Juridice. Have a wonderful day, all of you. Bye-bye.